The 10:30 a.m. docket for Wednesday, March 29th, 2023 consists of one case. Appeal number 122400. Elysia A. Marcus versus Eric Swanson, MD, Johnson County, briefs both sides.
Good morning. May it please the court, Quentin Templeton on behalf of Dr. Eric Swanson, prepared or present and ready for argument, and I'd like to request 3 minutes in rebuttal.
3 minutes granted. Thank you.
Morning, may it please the court. Matt Bartle for appealee Elysia Marcus.
Your Honor, that concludes our 10:30 a.m. docket.
Thank you, Mr. Shima. Counsel, please come forward. While you do so, I will explain to the audience, we do have an empty chair for this argument. Justice Wall has recused from this case. That means he will not participate in the arguments or in the court's conferencing or decision-making on this matter.
May it please the court. Good morning, everyone. Quentin Templeton on behalf of Dr. Swanson again. Just a brief overview for the benefit of our audience as well as our viewers. This case stems out of a 1-star review that was left on Yelp, the social media platform, review platform. Ultimately, a jury trial was conducted. The jury awarded $15,000 in damages in relation to the defamation claim. There was also a breach of contract claim that's not relevant to this case or to the appeal. There also is a punitive damages finding by the jury instructed under PIC under both willful and malicious. Post-verdict, the district court on a judgment as a matter of law took away the jury's verdict and said that there was no evidence of damages presented that could sustain a defamation claim. And then on appeal to the Court of Appeals, 2 members of the 3-member panel agreed and affirmed the district court, and there was a dissent issued by Judge Warner.
Counsel, you said the case concerns the 1-star review that was given. Is it really the star that was given, the 1 point, I guess, or is it the comments that were made as a part of that? In other words, kind of the review process, because I see a difference between a rating and the comments.
Sure. And this is an argument that Ms. Marcus raised in her briefs on appeal for the first time. So there's nothing in the record that supports being able to bifurcate or separate the star rating from the review. What I can tell you based on my experience of playing around with Yelp in this case, and again, we're off the record here. This is the knowledge of Quentin, not what's in the record. But my knowledge from playing around with Yelp is that you have the ability to leave a star rating on someone, but not the ability to only leave a substantive, a comment of someone. If you're leaving the comment, you necessarily have to leave the star rating. And that's because that's how the whole Yelp system works.
But I guess I'm trying to differentiate, because it seems to me deciding whether you get a 1-star ranking or a 5-star ranking, not a full statement of fact. It's an opinion. I mean, you know, Siskel and Ebert give you 3 thumbs up or, 4, whatever. That's not a provable falsehood. So the fact that you got a 1-star seems to be opinion kind of thing. I realize maybe you're just labeling this as this was the vehicle for the defamation, but because of the 1-star, 3.5-star, 5-star thing got talked about, I'm trying to differentiate that. You see what I'm doing? Won't you agree that making a decision between a 1-star and a 5 is a statement of opinion?
Absolutely.
And that cannot be actionable.
Correct.
Because it's opinion.
Correct.
Okay.
But and you're right, the issue of the star rating is talked about in the briefs, but in the context of evidence of damage. The rating itself, the substantive review itself, it's in the record. I'm confident the court has reviewed it. I have it here if you'd like me to read it, but says all sorts of things like he's a monster, he scarred my face, not licensed, et cetera, et cetera.
That looks like real, I mean, that looks
Correct.
like a typical defamation.
Garden variety.
kind of
Yeah,
thing.
that's
Okay.
standing in the public square and saying the cobbler makes bad shoes, right? The question to the court today in
Not
this case,
bad shoes, because that would be a statement of opinion.
shoes that
Makes-
scar my feet.
Makes shoes that injured my feet when it didn't injure my feet.
Right, correct.
Got to be a provable falsehood.
Absolutely. But the issue for the court today is there any evidence of damage? Not substantively, was there defamation? Because there was, and in fact, the district court didn't disagree with that. The Court of Appeals didn't disagree with that. Their argument, their opinions are all based on whether or not there is evidence of damage. And so the issue of the star rating is important because it's sort of by design of Yelp, it's the way that you measure someone's reputation on Yelp. And so if we go back to the cobbler example, sort of historically, the problem with proving defamation is how do you establish someone's reputation? How do you quantify that? And how do you quantify the change in someone's reputation? So the cobbler example, if in that time, we all had floating stars above our head and someone went down to the square and said, this cobbler makes shoes that harm my feet and required surgery, and it's demonstratively false, and it defames them, and the star dulls a little bit over their head, then we wouldn't have that problem. And that's what Yelp has done. Yelp has created a graphical way that we all can say, what is this person's reputation before the statement? What is this person's reputation after the statement?
Okay, but
But-
I understood you to say that the star rating itself is an opinion. The star itself is an opinion. So as to reputational damage, tying it to Swanson and actual effect, what is the best evidence to support reputational damage to Swanson from that opinion?
His star rating dropped. There are several. His star rating dropped from a perfect 5 stars to 3.5 based on this one review. 15 other 5-star
The
reviews.
evidence, you say based on it, is it a mathematical bent? In other words, 5 people give a number and the average dropped because of the one number, as opposed to all these nasty things that were said caused other people rate him lower.
It is the former, but because 15 5-star reviews because of this one review were relegated to a secondary not review or not recommended page. So it's this complicated process. I don't work for Yelp, but there's a short little explanation in the record on the actual Yelp
So does
review.
it matter when, it seems like timing matters. What if this was the 5th review? There were 4 perfect and one, wouldn't it put it even lower? It just seems like we're kind of speculating on, or it's just left up to chance of the impact of one negative review. It could be, if it's the 2nd review, it put it way down. If it's the 100th, it would have little impact. Am I right?
I believe you are right about that the amount of impact changes based on the number of reviews, but that's not the end all be all here. Number one, the standard of review is that Dr. Swanson gets all the reasonable inferences. So of course we can come up with scenarios where the impact of the review might have been less, but we have to draw those inferences in favor of Dr. Swanson, not against them. And there's other evidence of damages beyond just
So
the
you're
star
asking us
rating.
to presume damage from this reasonable inference, as opposed to it being a provable element of the claim.
No, because there's other evidence of damage as well. For example, Dr. Swanson testified that he spent hours of his own time trying to get the Yelp review taken down.
Damage to reputation. What is your damage to reputation? Not income, or if it is because of reputation, what ties reputation to?
Well, the standard for defamation, as I understand it from this court, is not that it is that the defamatory statement has to damage the individual. It has to cause the damages. And there has to be some reduction in the person's reputation or standing in the community, but there can be other evidence of damage that can harm the individual that if you take it back to Moran, the court's talking about, or excuse me, Gobin 3, the court's talking about whether or not those other elements of damage are parasitic or not, right? Do you have to have concrete drop to a reputational injury before you can have pain and suffering, for example? And the test that the court adopted in Gobin 3 is that if there's, it's described as the New York test, if there's evidence of malice, then you don't have this parasitic concern. You can go straight to pain and suffering alone. There doesn't have to
You
be.
still have to have damage to the reputation in the community. And that's where I think the focus is before you can talk about how much effort he tried to even prophylactically avoid damage to his reputation in the community. You've still got to get that. And that's where I think you got tagged by the district court, the way I'm looking at this.
I actually don't think that's the case. I think that what the district court did is the district court believed that the jury got it wrong, and so he reweighed the evidence. And I think the Court of Appeals expressly did that. For example, the Court of Appeals in its rejoinder to the dissent says, for all the trial record shows, visitors to the Yelp page may have routinely dismissed the post as a hysterical rant, unworthy of credence, or the work of a gallivanting internet troll randomly lobbing fake bombshells for his or her misguided amusement, and those skeptical visitors likewise would have discounted the aggregate rating. That's textbook reweighing of the evidence, because that's actually, take a step back. That's not even reweighing of the evidence, because that's not in the record. No one testified to that. The Court of Appeals made that up of whole cloth and said, well, this could be an explanation, but that's the exclusive province of the jury.
What's your evidence of the opposite? That this impacted his reputation in the community?
Sure. So there was a patient that came in, and again, this is a problem that's discussed in Henry Rockwell, the Court of Appeals opinion, which is a defamation case involving physicians. And the Court of Appeals says, my gosh, how do you ever find everyone who never called you, right? When you're defamed and the patient doesn't call you, how do you find them? So we're allowed to have these reasonable inferences of damage. And Ms. Hart-Neufeld comes in and testifies. She's a prior patient of Dr. Swanson, so she has an experience with him. And then she wants to have a second procedure done, searches online and finds the review. She testifies, I know Dr. Swanson, and therefore I know that this review was false. She felt that it was damaging, so damaging in fact that in addition to notifying Dr. Swanson, she tries to post her own review to try to mitigate the damage done to Dr. Swanson for this. Excuse me one second. And from that, the jury is able to make a reasonable inference that had she not known him, she would have been dissuaded from ever seeing
Why is that a
him.
reasonable inference? I mean, it almost seems to cut the opposite way, that you generated a positive response. Doctor.
That the negative review generated positive responses from patients. Yeah, I mean, that might be one way that one could infer that evidence.
I guess
That's-
I don't know. I'm probing into the reasonable inference here.
Right.
It strikes me as a loose connection, let's
Right.
say.
And this gets back to all of this court's jurisprudence, that we place it in the hands of 12 jurors because we trust those people to weigh the evidence, not one district court judge or two members of a Court of Appeals panel.
But didn't she testify that in her mind, his reputation was not harmed, but that it could harm reputation as to someone else? Isn't that what she testified to?
Yes, I believe she did. And my point is, you can draw, the jury is entitled to draw the reasonable inference from that her opinion was unchanged because she already knew him. For example, if Justice Wall defames Justice Biles.
Happens every day.
I believe that. I don't believe it would impact Justice Standridge's opinion. But someone who doesn't know Justice, or maybe it would. Maybe that's a bad example.
You know, I think
You
you better,
could've picked
I think you better
anybody.
stop.
You shouldn't have picked me.
But if Justice Biles or Justice Wall is defaming Justice Biles to someone who doesn't know Justice Biles and has no idea who he is, it might actually cause damage. And if Justice Standridge comes in and says, yeah, I heard Justice Wall, but he's always saying these things. And I also know Justice Biles, and I know they're not true. But yeah, I mean, it's pretty bad what he was saying. And I think it might hurt his opinion or his reputation.
How
with
does that
someone
add
else.
anything to the fact of the post? I mean, isn't that just kind of rank speculation that anyone could make based on the post itself?
I don't think so. I think it's a reasonable inference. And I think
No,
it,
but how is that testimony evidence of a reasonable?
because her testimony isn't that this could have impacted anyone. Her testimony is that it didn't impact me because I knew him.
Right, but how do you connect the dots to evidence that it would have been reasonable for a different person to have a more negative view of the doctor? She never says anything close to that.
Because she doesn't know someone.
Right.
Right.
I mean, there's just, well,
Right.
that's the problem. Is there actual evidence that would allow the jurors to draw this reasonable conclusion? Aside from the post itself. I mean, that strikes me as your argument, is that just look at the post and then we get the reasonable inference.
Well, I think that's right. I mean, I think if Justice Wall were calling Justice Biles a monster and he scarred my face and he got his law license in Canada.
And that leads to, I mean, one of my questions about this case, which goes to the broader, I guess, the nature of online discourse. I'm struggling with words to try to describe what it's like.
Right, I
Obviously,
understand.
I think maybe we all know what I'm referring to. Does that come into play here at all to sort of reduce or maybe even eliminate that reasonable inference about what people might conclude based on online statements?
Not in this case. This wasn't someone started their own blog or is sending a chain email around. This is on Yelp. It is the review site that Dr. Swanson's testimony is. It's the review site that he basically monitors nonstop because it drives patients. So this isn't the amateur newspaperist who's writing about the court. Or
Was there
someone else.
evidence that the general public gives greater credence to things that are stated on Yelp than they might give to things that are stated on Twitter, for example?
I don't believe there's anything in the trial record about that comparison, no.
So the reliance on Yelp as being the means by which he's defamed, or the mechanism by which the communication is made, was validated somehow. That just a broader question. Where does Yelp fit into this? The doctor testifies he monitors what's on there, but was it, for instance, I'll confess, I'd never go to Yelp for anything. And I think there's a lot of people out there. So how is it that you established that that was a means, a credible means, by communicating the defamation?
Yeah.
How does that work? Because,
So Dr. Swanson testified to it and testified to the impact on his own practice and what's posted on Yelp and reviews on Yelp. And Ms. Hart-Neufeld also testified that she I haven't read her testimony as recently, but I think she says, in essence, when she's looking for a new service provider, she exclusively uses Yelp. And so again, we get back to the reasonable inference that the jury can draw a reasonable inference, and our jurors don't go into the courtroom unarmed with their own common sense. If they use Yelp and they know what Yelp is, Justice Rosen, you might have been someone that we wanted to get struck off the jury because you don't know what Yelp is. But someone who does, or jurors who do, can use that common knowledge in their own experience. And what we know is that they did, and they felt that this did damage his reputation. But we're not talking about some crazy runaway jury verdict. You know, Henry Rockhill was 61 times the damage award here. Moran at summary judgment was 216 times the $15,000 in this case. And we're talking about a very, very minimal amount of damages. So in terms of what evidentiary hurdle is required to establish $15,000 in damages for a plastic surgeon in Johnson County, we're talking about a pretty low threshold here. We're not talking about millions.
Well, I think, everybody agrees it was defamatory, right? in the first instance. But something that you said, that Dr. Swanson said it drives his patient, drives patients is what you said. So in other words, it drives his business model. That's what it does. Was there evidence that his gross sales, is that what you say for a business practice, went up or down?
Yeah, so the evidence at trial is that he did not have a reduction in revenue for his business or sales for his business.
So
There's no,
isn't that kind of indicative of?
no, I don't believe so, because this court repeatedly has said embracing Gertz, the US Supreme Court case in Gertz, which I'm blanking on the justice who wrote Gertz in 74, but in essence says like jurors are capable of understanding when someone's been damaged and not. And so there's no finite requirement to present a dollar amount of, I lost this much in revenue.
But
And that was an
Gertz-
issue
but
in
we don't
Grant.
apply Gertz, right? In Kansas,
We do.
but we don't do damages per se, right?
Well, that's the second issue. So I appreciate you taking me there, Justice Standridge. But Kansas actually does. And in fact, many states do have defamation per se. So defamation per se was first called into question in Gertz. And in Gertz, the court said, states can no longer have presumed damages under a First Amendment concern, quote, when liability is not based on knowledge of falsity or reckless disregard for the truth. Now, that is the articulation of actual malice out of New York Times v. Sullivan. Now, this creates a little bit of a problem because actual malice in Kansas is a much higher standard. Actual malice in Kansas
But
is,
this wasn't raised below, right?
it was, yes, ma'am.
Was there anything in the pretrial order, the requested jury instructions, or the jury instructions actually given that allows the jury to presume damages for any reason?
No, but that's not a requirement because presumed damages just means that the district court can't throw the case out for a lack of damages. It doesn't bar the jury from awarding in excess. And our position was he's been massively damaged. The jury obviously disagreed with our amount and came up with 15,000, which isn't massive or excessive, but there's no under presumed damages. It's just a legal mechanism that stops the court from throwing it out for lack of damages, which is what we have here, which is why it's important on appeal.
What are the actual damages?
Well, so the reduction in the star rating, dropping it from 5 stars to 3.5, 15 5-star reviews getting moved to a secondary not recommended page. Ms. Hart Neufeld saying,
How do you balance that against the fact that, his business is great and he's been asked to more? I forgot what all the things are. I mean, it flies in the face. Here's the evidence. His revenue, profit, and patient count has actually increased. He continues to be invited to speak at professional conferences. He continues to be published in peer-reviewed journals, and he serves as a peer reviewer.
and
There's no evidence that the Yelp post led to reputational damage.
well, I disagree with that last part, but that is part the crux of the case, right? It's that we put all of this information into the hopper, all of this evidence into the hopper, and we trust the jury to figure it out. And then we don't come in on the back end and say, well, I'm not really sure I agree with that. So I'm going to reweigh the evidence and say, come up with another scenario where more Yelp reviews would have meant less damage. And so we're just going to throw the case out.
But we have to make the connection so that it's not just he might be damaged. There has to be an evidentiary connection to actual evidence to allow the jury to infer his reputation was harmed. There has to be something tied to what happened, Dr. Swanson. So income is one thing that has been tied to that reputational damage. The case of the KU medical doctor, he was no longer called. He wasn't asked to do any more peer reviews. He wasn't asked to make any more speeches. Could point to that happening after the defamatory statement as a cause and effect type of thing. What is the effect part that is the tag to show that his reputation has been harmed. You had the one witness who testified, well, it wasn't harm to me, but it could have been harmful to him with someone else. And you have the doctor's testimony that, well, this was personally harmful to me because I've spent money trying to take this off of the internet. And yet he didn't say that there was some evidence that other people thought less of him. So what is there? I mean, other than I'm extrapolating this, it's a circular argument. Take me out of the circle of the star rating went down, therefore my reputation went down. The star rating went down, then what happened to him? Oh, reputational damage.
Well, I don't think that is a circle, Justice Wilson. I think that the reduction in that the star rating is a graphical representation in the business community in Johnson County of plastic surgeon. And I don't know how you could have better evidence other than a drop in revenue, but that's alternative evidence. I'm not sure that that's better evidence of someone's reputation dropping in the community. There are all sorts of reasons that people might not undergo a plastic surgery procedure in a certain point in time. But if we're looking for what is Justice Wilson's reputation in the community, Yelp's a pretty good indicator of
Well,
that.
how do we know that? I mean, I don't know if there are Yelp reviews for justices, but
I don't know
mean-
either. And I've not posted.
how would we, maybe I should say, I appreciate that, but that's a humorous example perhaps, but it illustrates the more serious point, which is doesn't the plaintiff in this case or similar cases have a burden to demonstrate that this platform carries authoritative weight of some kind? You're just assuming that. And you're asking us to say, well, the jurors were allowed to assume that with no evidence that Yelp carries weight in the community.
That's not true. That testimony comes directly from Dr. Swanson and also Ms. Hart-Neufeld. Ms. Hart-Neufeld is an average consumer. She's not an expert witness. She's just a former patient or a current patient. And she testifies that, yeah, I go to Yelp all the time when I'm searching out reviews. And Dr. Swanson testifies, this is really important to my business. So there's your direct concrete evidence of Yelp's impact on his business. Now, maybe that doesn't reduce his revenue. Maybe his revenue isn't reduced after the post is live and the star rating has dropped, but that doesn't mean that his reputation in the community hasn't been impacted. Your Twitter example, for example, if someone's out on Twitter blasting an individual, let's even say Dr. Swanson, and talking about how he scarred their face, and that's posted out to everyone, well, I do think that you can come in and the jury isn't leaving its common sense at the door and saying, well, I don't really know what Twitter is, and I don't know if any patient looks at Twitter before they hire someone. That's the point of Yelp. That's its whole design. It's not like you're posting what you did that day or you went to the park with your kids and have pictures with your grandkids. It is designed for people to evaluate businesses. And when that star rating drops, I can't imagine better concrete, physical, visible evidence of someone's reputation in the community lowering.
But you have no evidence that ties the drop in the stars. That was my first question. You have no evidence that ties the drop in the stars to the defamatory statements, because we've all agreed when she gives just 1 star and it's a numerical average, what you get, that's her opinion. So you don't get to look at the star rating to try to establish damage in the community. You've got to tie the defamatory statements in the written part to some injury out in the community. And that's what's lacking here, it seems to me.
I don't think so, because envision that they're separate.
I am envisioning it separate
Okay,
because you didn't
great.
agree
You're
they were
already there.
tied.
You're already there with me. Okay, they're totally separate, right? Let's even say that she posts the star rating later, which I don't think
Let's
she
assume there's
did.
no written statement. Let's assume all she's doing is she
Is
gets the
lowering
chance to
his-
give him 1 star or 5 stars.
No defamation.
That's my point. So you can't go back and look at the star rating to try to claim some defamation, because that's all a function of a number with no criteria. That's just got to be opinion.
Well, then defamation never exists.
Sure it does. And it would exist in the written part that makes the material statement of falsehood.
Yeah, but that would never be actionable unless
what-
this court wants to hold that you have to come in and say a drop in revenue.
Isn't it a causation? I mean, what we're talking about here, it strikes me as causation. In other words, your claim is damages equals 3.5 on Yelp. That's my damage.
One of.
The
sure.
question is, did the defamatory statements cause the 3.5 on Yelp? And I think, at least if I'm understanding Justice Powell's questions correctly, the question is, isn't the 1 star rating what caused? To the extent there is we grant for purposes of questions that there was reputational harm. It's exactly as you described. It's the Yelp rating review. You can't connect the causal link between the defamatory statements and the damage, because in between those two is the subjective 1 star rating.
And that was my point in saying that defamation's never actionable then, because the drop in every defamation, there's always the comment of, and I don't think you should go to him, or, and I think he's bad, or there's some sort of attempt to dissuade people from seeing that person, right?
It continues to make defamation difficult to prove. It is a challenging tort
Sure.
to begin. I mean, it is absolutely a challenging thing to show damage in the community, but you've got to show your damage as a result of the actual defamatory statements, which have to be a material falsehood.
So 2 responses to that. Number 1, that's why defamation per se exists and has since 1904, because the 1904 case in Kansas is an individual calling someone a eunuch. I'm not sure how that's actionable, how you can show concrete damages ever from just being called a eunuch. That's why the court over time, the common law has created these very concrete areas of per se liability, because as the court has articulated, it's so unconscionable to defame someone in certain areas that damages are presumed to flow from that defamation. That's the basis of per se defamation, which handles your first or your concern. The second issue is that, or the second response to that question is that I don't think you can separate out the two. In the age of the internet, in the age of Yelp, the Yelp rating and the reputational opinion in the community cannot be separated from the reviews. That's how the whole website is set up. They're just tied together. They just are. That's what it is.
So you say res ipsa loquitur, the thing speaks for itself. If there's a bad Yelp rating, then the reputation must be harmed.
No, that's where the categories of per se defamation come in. And what it means is, if your work is one of the per se categories, if that's why we use the cobbler example, and Dr. Swanson's job as a plastic surgeon is being questioned in the Yelp review, which is why it fits into the per se category. If you're in those categories, then yes, that's absolutely been the law going back to Blackstone. I mean, just from time immemorial, the standard has always been, if you criticize if you defame someone in certain categories, sexual ability, I think is one of them. I think promiscuous, a woman being promiscuous, and it's limited to just a woman being promiscuous who's married, these certain categories, then yes, we do as a society say what you have said is so repugnant that person's not required to come in and show even a scienter of damage in order to get their honor vindicated, because we don't allow dueling.
Because damages are presumed.
Right.
But you don't have an instruction to the jury that they can presume damages from that.
And we would have needed one had the jury come back and said no damages. But the jury came back and said damages. So we don't need a jury instruction because they already said he's been damaged. They came back with that verdict themselves. They weighed all of the evidence in the hopper and said, this person's been damaged, not 2.3 or 3.25 million or $925,000 in damage, but $15,000 in damage.
But that only relieves, per se, only relieves the plaintiff, you, from having to cause have that causation element to show causation of reputational harm. If you don't have the presumption, you still have to show causation.
Yes, yes. And I think I don't think the causation can be clear. And I understand some of you disagree with this. I recognize that, but I don't think the causation can be separated from the review to the drop in the star rating. Had she posted just the review and not a star rating, which again, in the world of Quinton as lawyer, having researched this, I don't think you can do, but it's not in the record because Ms. Marcus never raised this argument at trial. Had she just posted the defamatory review without the star rating, this would be a different case. I wouldn't be able to argue what I'm arguing, but she didn't. She posted both.
What if she posted the review and a 4-star rating?
It's a different case. It's a different case. Now, the damage might be less, but that's still a drop in his public rating. It is the rating. The star rating is your
If
reputation.
there was a 5-star rating in accompanying the identical review, would you say there was no damage?
No, I think there's other evidence of damage. That's where Ms. Hart-Neufeld coming in and testifying as to what a reasonable person in the community would see. That's his staff time, his own time, the other reviews getting relegated, him hiring a consultant to try to get the review taken down. All of these things are evidence of damage. So even if it's a 5-star rating, even if there's no rating, there's still other evidence of damage that supports the jury's verdict of $15,000. And that's why we trust them to make these decisions.
Reputation. I mean, those hours spent and consultants are not reputational damage.
Right, but that gets us back to Gobin 3 and this question of parasitic harm. And with a finding of malice, there is no parasitic harm issue. Under my reading of Gobin 3, if you have a finding of malice, you can jump straight to emotional harm. You don't have to go through any sort of, I have other damages that are related to my reputation.
You agree that your entire case for reputational harm is based on inference?
The reasonable inferences, no, I don't actually. The star rating is, the star rating is not a reasonable inference. It's objectively obvious. Ms. Hart-Neufeld is the reasonable inference that the jury's drawing.
What other testimony is there that is direct testimony of harm to reputation?
Well, not testimony in terms of live witnesses at trial, but I was saying the star rating itself.
Only the rating is direct evidence.
Correct. Of harm to reputation, not of damages as a whole, but as harm to reputation. Correct. There are no further questions. Thank you.
Good morning, Madam Chief Justice. May it please the court. My name is Matt Bartle and I represent the appealee, Elysia Marcus. There really is no reason to abandon 41 years of jurisprudence. And that's exactly what Dr. Swanson is asking you to do. Since you authored Gobin 3 in the early 1980s, and then it was affirmed again in 1999 in the Moran case. There have been 14 Kansas Court of Appeals cases that have restated your standard. If you include the federal courts that have looked at the standard you set forth in Gobin, the number jumps to 56. Then it's interesting to go see what other states have done with your Gobin opinion. It has become a leader in the country. And leaders for courts that are considering these issues long into the internet age, as late as in 2012 in New Mexico.
Would agree though, wouldn't you, that Gobin 3 went farther than it had to in order to comply? What came down from the Supreme Court in Gertz?
Justice Wilson, it's interesting. If you look at the Supreme Court jurisprudence, they're concerned with minimum standards. So that obviously we're talking about protected First Amendment speech. So the Supreme Court says under the US Constitution, First Amendment, there's certain things the states cannot do. If the states want to set parameters that protect free speech more than this, that's okay.
So
We
your
give them
answer
the
is
freedom to
yes.
do that. So the answer is yes. And what Gobin did is Gobin set forth a standard that basically it's a two-part test. And Gobin came in and said, the gravamen of defamation, the essence of defamation is proof of reputational harm. First, you prove that, and then you move to, then you can have the parasitic damages, which would be the kinds of damages that Dr. Swanson points to. But yes, the answer is, what can you do? The US Supreme Court gives you, as a state Supreme Court, a great deal of leeway to set the parameters.
And what we said in Gobin 3 was that you have to prove damage to reputation. So we essentially did away with per se defamation when we didn't have to under the standards set by the Supreme Court, correct?
Well, there are a set of circumstances where if you are going to allow a presumption under the constitutional jurisprudence, and this would be not just Gertz, but Gertz and its progeny, that if you are going to allow for presumed damages, then you would also have to have proof of actual malice per the New York Times standard. So that's one of the kind of four.
You have a private person against a private person on a private matter. Kansas would still have been able to say you can have presumed damages if you've got actual malice or reckless disregard for the truth.
Right, yeah, but you have to have the New York Times standard
And that's
of
what it
malice,
is.
and that needs to be in the instruction. And the jury would need to consider that and find that, and that's the only way you could skip a reputational harm. But Kansas and a lot of other states have said, hey, I think the way the court was reasoning is that's not completely a clear formulation, the best way to do it. Let's say let's establish for the cause of action of defamation, its essence, its gravamen is reputational harm, and we're not going to allow the bypass of reputational harm to get to other sorts of damages. To prove defamation, you have to prove reputational harm. And then what's happened after Gobin is courts have said, okay, here's the kind of proof that you need for reputational harm. Now, we have in the state another tort in false light, which we briefed and talked about, invasion of false light. And what that allows someone to do is when there's been no inability to prove reputational harm, they can still obtain damages and injunctive relief.
Is there any way that the jury could have presumed damages in this case under the instructions that were given?
No, because Dr. Swanson did not ask for any bypass of proof of reputational harm.
But he said he has instructions about malice. So if malice is found and damages are found, can that connection be made by us? As the appellate court?
No, because what the punitive damage instruction, well, first of all, Dr. Swanson he specifically submitted an instruction that would require him to prove reputational harm. Okay, that's problem number one. Why this case doesn't really present a clear or good platform for you to rewrite the rule because he's essentially waived it. He said to the district court, the law of this state requires me to prove reputational harm. Then he did not do it. But then there was also an instruction on punitive damage. But that instruction did not give the New York Times formulation of what actual malice is. And the Kansas punitive damage instruction allows for a finding by a jury of malice or willfulness, which are actually defined two different ways in the pick. So this is not, it would be impossible under Gertz for you to reverse and not send it back down for a finding by a jury, whether there was the actual malice per the New York Times definition.
I mean,
But-
your point is jury's path to finding defamation had to include an element of community reputational damage. And no one asked about malice or really presuming damages in that or presumed defamation, if you will, because the New York Times standard wasn't used. The malice instruction is instruction 17, and it's connected to just the punitive damage aspect, which is just the intent to do harm without any reasonable justification or excuse. So our focus is on whether defamation occurred, whether the elements were proven. That's the way you're getting at this.
That's stating it
Okay.
quite well. Yes.
Can I ask you a procedural
Sure.
question? And it may be in the record, and if it is, I didn't see it, or anyway, did you, on behalf of your client, file an early motion under the anti-SLAPP statutes?
No. No.
Counsel, I have a question about
Sure.
how juries function and then how it would apply to this case. We often say jurors are permitted to use their common experience in reaching their verdict. Would you agree with that?
That's true.
What does that mean?
I think of it as a good old fashioned common Kansas horse sense, as my granddad might call it.
Old fashioned Kansas horse sense evidence?
Is it evidence? No, it's not evidence.
So
It's
are we
it's
saying-
basically your brain power.
Well, are we saying that jurors can use something that's not evidence to reach their verdict?
They have to have some evidence. You have to give them something. There has to be at least something, according to Gobin here, Gobin says you have to have proof of reputational harm. So you have to have some proof of reputational harm for them then to apply that Kansas horse sense. And the problem in this case was they were not given anything. And in fact, Dr. Swanson took the position.
Yes, and I understand that's your position. And, obviously that's the central argument at the Court of Appeals and obviously here on appeal. It just occurs to me, we say this very often, jurors can use their common sense or their common experience, which on the surface sounds very understandable. It's like, well, that's obvious. But if you sort of drill into it, to me, at least, it's an interesting question. Like, what does that actually mean? Okay, maybe it's old fashioned horse sense, but what is that? What is old fashioned horse sense?
Right.
And how does that interact with evidence?
Justice Stegall, your question is reminding me of something that the New Mexico Supreme Court wrote when considering the very issues that you're considering here. And, it noted that you have First Amendment protections on speech because we human beings are prone to have prejudices about speech. They can inflame us. And so these are guardrails that are put up in the system because collectively we as citizens of the state or people of this country have said, this is really important, and applying good old Kansas horse sense might lead to a result
so
that we
that
all
goes-
really
your
don't like.
Point is going directly to my follow-up question, which is, it strikes me that your argument, which you've just stated, is that maybe here jurors really shouldn't be allowed to use their common experience. Because it's clear, at least maybe reading a little bit between the lines, but not too much, it seems clear the jury was not happy, at least at a moral level, with what your client did. They asked the judge if they could force her to take the post down. So they didn't like the post, right?
Yes, clearly.
That would be arguably, what we're calling old-fashioned Kansas horse sense.
Well, imagine, Justice DeGaulle, that instead they had in front of them, or they had pled invasion, the false light tort. Their injunctive relief would have been available. Reputational harm wouldn't have been a impediment. So, here's the cautionary tale. And I think this is what Gobin and other courts that have examined this issue is they realize this has such consequential effect. I mean, what you're going to do in a case like this has enormous impact, but there are other avenues to address what you might say is a modern challenge. There's a post out there. The jury wanted it down. That's clear. Very clear. The jury was super frustrated because they didn't have any really proof of reputational harm. And with two different questions, and the Court of Appeals read this exactly the way I felt when I was living it, which, by the way, it was not pleasant. I think they got it right. They were frustrated. They'd just been told in closing arguments there was no reputational harm. There were no damages. They'd been told that by counsel. The doctor repeated it. Everybody, his whole theory of the case was his reputation was wonderful, in spite of a lot of other garbage out there not related to her post. And they were frustrated. They wanted that post down. And so I think you had them kind of but this is why you have to have a rule.
But this is how I read the dissent. And maybe it's unfair, and I might be putting words in Judge Warner's mouth that she didn't actually say or wouldn't want me to put there. But the overall sense of it I get is, look, some problems in society, we just trust to the black box of the jury room. And I don't want to disturb that. And I have to say, there's some attraction, and there's a long pedigree of judicial history behind that view, that we're just not going to parse too closely what happens, because there is kind of a, for lack of a better word, street justice that might go on here. What would be your response?
I would say if you're inclined to go in that direction, you are going to functionally, or have to literally or functionally, reverse yourself on Gobin. And you're going to have to tear out 41 years of legal scaffolding to do it.
To put what I just said in legal terms, this would be a reinstatement effectively of.
Exactly. And you're going to need to send us back down because we're going to have to retry this case. But I mean, that's where tread carefully, because they're asking you, you're going to have to get rid of Gobin to hold in favor of Dr. Swanson. And that's going to have a lot of radiating effect. And this is where on First Amendment speech, it is super, super important. Beware of this. This record shows why this is so important. Dr. Swanson in this record we showed it that he has used threats of litigation against other people who have said things that he didn't like. If you start moving the law here, one direction or the other, you can place in the hands of people who will use the tool in ways that you do not intend for it to be used. And the New Mexico Supreme Court does a really, really good job with this. They talk about a situation where if you abandon proof of reputational harm, you create a situation. And this is where, and they don't use this example, they use the word hoodlum, but you a situation where a school shooter somebody says something on a online review of a family member of a victim of a school shooter says something that is completely untrue with reckless disregard to its truth or not, and can be open to a claim of defamation if we dispense with any sort of proof of reputational harm. So, there are a lot of impacts with what this court might do here. And this is just, if this court was wanting to create a bypass around proof of reputational harm, which you stated so clearly, and others have now followed, and wanted to create some sort of bypass, this isn't the case to do it, because they've not preserved the issue properly. And the facts of this case are just so doggone bad. The bar is already really, really low. If you look at what you said in Moran about what kind of proof is needed, or you look at Rock Hill, these are actually two cases involving doctors. Oddly enough, you've got two doctor cases. But they talked about these doctors and how little they actually had to prove reputational harm. This is not a great case in which to completely reverse yourself on Gobin 3 and rewrite defamation laws, which, by the way, remarkably, writing in 1982, this court was remarkably farsighted and set forth a rule that others years later are calling modern, like well suited to the new day and age. So with that, thank you, Your Honors.
Reserve 3 minutes.
I'm a little confused because what I thought I just heard from the discussion with the court is that the court abolished defamation per se in 1982 in Gobin 3. But just to read to you from this court's words in Moran in 1999, this court has not yet squarely decided whether in Kansas, any and all defamation plaintiffs must allege and prove actual damages rather than relying on a theory of presumed damages. So this idea that Gobin 3 abolished defamation per se, it's just not true. And in fact, in Gobin 3, what the court adopted was the New York rule, which is defamation per se upon a finding of malice, which is the same language out of Gertz in 1974. Or actually, Gertz, I guess, uses New York Times v. Sullivan, which is actually reckless, which is what Justice Wilson was asking about. So that dovetails into this idea that we have to go back and retry the case because the jury wasn't asked if her conduct was reckless, which Justice Wilson asked. And the answer to that question, Justice Wilson, is that the jury found willful or malicious in the punitive damage finding, which only applied to the defamation tort, which addresses Justice Biles' question of, well, maybe that's just for punitive damages. It only touches on the tort of defamation, not the breach of contract case or claim. So they've already found willful and malice. And if we're looking at rungs on a ladder, reckless or wanton in Kansas is below that. So we've already cleared the actual malice standard out of New York Times v. Sullivan. This idea of, well, they could have filed a false light invasion of privacy claim. We hear this for the first time on appeal in the reply brief that he filed. Number one, that has to deal with a private life. So I don't actually think it would apply to Dr. Swanson's case at all. And there's no judicial theory or canon that you can throw out jury verdicts because the plaintiff might have been able to bring another claim under a different claim. At the end of the day, what we're dealing with here is Section 5 of the Constitution, which this court has said the right to a jury trial is inviolate. And is that a check the box sort of exercise? Once he has a right to a jury trial, can the district court judge go back in there and start meddling around and reweighing facts and coming up with ideas that, as the Court of Appeals did, that someone might have thought this was a gallivanting internet troll? To Justice Stiegel's question about sort of the black box of the jury, and maybe there's an element of rough justice there. That's why this court clearly articulated in 1955 The theory of the jury system is that it is safer and wiser for 12 people from various walks of life to draw the proper inferences from testimony than to leave it to a single judge. Because that black box is better when you got 12 hands in there versus one from the district court or two from a panel.
Your position today that the instruction that refers to actual malice or willfulness not intended merely to address punitive damages?
Our position is that it doesn't just address punitive damages, that finding, the finding by the jury on punitive damages means it clears the actual malice requirement for defamation per se. So there's no need to go back and retry this whole case again so that the jury can say, yeah, it was also
And
reckless.
defamation per se would release you from the obligation to prove causation, correct?
Correct. No requirement of evidence of damages.
But the elements instruction states that you must prove reputational harm, correct?
Mhm.
How is that
Why is it not waived? Is
Why
it sort of the
isn't it-
waiver?
inconsistent?
Right. So this would be an issue in the case if Dr. Swanson had not obtained the jury verdict for 15,000 and had not obtained the punitive damages award. But because he cleared the hurdle of the jury saying, yeah, there's actual damages, that's not a waiver of the legal argument to this court after, take a step back. At no point in the case until after the jury verdict did the district court say, oh yeah, there's no evidence of damages here. And so there's no point at which you need to assert, well, wait a minute, you can't throw that out. This fits in a defamation per se category, which again, the school shooter case that's not a defamation per se category. So you're not opening the floodgates there. But there's no, because we cleared the hurdle of a jury finding, we're not punished on a legal argument that says, well, you can't throw it out anyway.
Saying because there's a jury finding, we must assume causation.
Under defamation per se, correct. Correct. Thank you.
Thank you to both counsel for your arguments. The court will take this matter under advisement and we